Bonjour. My name is Renaud-Philippe Garner, and I'm an assistant professor of philosophy here in the Department of Economics, Philosophy, and Political Science at, obviously, our University of British Columbia Okanagan campus. But the reason why I'm here today, and the reason why you're here today, is that I'm proud and pleased to introduce Jean-François Kervégan. Our guest has many titles. A graduate of l'École Normale Supérieure de Saint-Cloud. This is an elite school, part of the Grande École system. We can discuss moving and change of addresses later, but he also has the distinction of having achieved what is called a doctorat d'état, which quite literally translates as a state doctorate. For our purposes, just think about it as a very long and very grueling PhD. Today, the man before you is Professor Emeritus at Université de Paris Panthéon-Sorbonne, and he has been so since 2019. It will therefore be no surprise to you that if he's presently an emeritus at Panthéon-Sorbonne, it is because he taught there for many years, training cohort after cohort, supervising student after student. During the academic year 2012-2013, I was twice privileged. He was my teacher for a year-long seminar on philosophy of law. He was also generous enough, or imprudent enough, depending on your view, to supervise my master's thesis. But that is a detail. While at Panthéon-Sorbonne, he's also founded the research group NoSoPhi, which stands for Normes, Sociétés, Philosophie, and translates as norms, societies, plural, philosophies, plural. And it'd be remiss of me to fail to mention that he's an honorary member of l'Institut Universitaire de France. Yet titles and honors come second. At least they come second when they are deserved and worth mentioning. First must come the work. For years, his research has been at the crossroads of philosophy of law, political philosophy, and classical German philosophy. He's the author of numerous works, and I cannot name them all, but I will name a few, such as Hegel, Carl Schmitt, politique, entre, spéculation et positivité, which we could translate as Hegel, Carl Schmitt, The Political Between Speculation and Positivity, published in 1992 with PUF, Presse Universitaire de France. Que faire de Carl Schmitt, What to do with Carl Schmitt, published in 2011 chez Gallimard, or his very recent, and the subject of tomorrow's talk, La puissance des droits, we could translate as The Power of Rights, 2025, again, Presse Universitaire de France. He's also translated and commented classic works, such as Hegel's Principes de la philosophie du droit, which in English I suppose it's translated often as Elements of the Philosophy of Right, 1998 PUF, at least one of the editions. Thus, he's worked on very challenging authors like Hegel, but he's also worked on authors that are more than challenging for their complexity. He's worked on authors that we might describe as dangerous. And it is the latter that will concern us today. Jean-François, c'est un grand plaisir de t'avoir parmi nous. Welcome to UBCO.
Thank you. Thank you, Renaud-Philippe. I'm very happy to be here to the first time in your university. And I beg you pardon for my poor and inconvenient English, but so it is. So, I came across Carl Schmitt's work around 1980 while reading the only book of his that was then available in French, the translation of Der Begriff des Politischen, concept of political, from year 1928, together with a translation of the Theory of the Partisan from year 1962. I knew little or nothing about the author, and Julien Freud's laudatory preface, despite his valuable knowledge of Schmitt's writings, did little to enlighten me. It underestimates, in particular, the intensity and duration of Schmitt's involvement with the Nazi regime. To tell the truth, my encounter with Schmitt's writings was not purely accidental. Like many French intellectuals of my generation, I was influenced by Marxist thinking, but like many others, I was frustrated by the absence of an actual theorization of politics in Marx and his successors. Hence, the idea of looking elsewhere even if that elsewhere was far removed from Marxism, even completely opposed to it, for elements that might overcome this deficiency. My first reading of Schmitt fascinated me, a feeling shared by many new readers of Schmitt, and one that I gradually had to learn to shake off, because the seductive power of Schmitt's brilliant style and effective rhetoric detracts from the critical distance that must be maintained toward his thesis. However, this led me to undertake an extensive reading of Schmitt's writings, which was made easier by the fact that I was a guest fellow of a German research institute in the late 80s, where Schmitt's writings were much more accessible than in France to that time. Now is quasi the totality of Schmitt's writing translated, so in English, I mean, but to that time it was absolutely not the fall, in English or in French. Only in Italy, there was an intensive reception of Schmitt. I speak about that in the book. Okay. As is often the case in research, oh, le pauvre. As is often the case in research, what I found in these writings, a powerful conceptualization of law in its relationship to politics, but also to other fields, such as theology, it was very different from what I was initially looking for. And this had a significant impact of my personal profile. From reading Schmitt and other less dubious authors, such as Karl Polanyi, whom I also discovered during this period marked by a major event. You have to drink something. A major event, the collapse of the Soviet Union. I emerged no longer really a Marxist, but certainly not a Schmittian either, if that adjective has a substantive meaning. Indeed, unlike some unconditional Schmitt's apologists, such as Helmut Quaritch or Günter Maschke in Germany, the latter being the author of an outstanding editorial work, or Julien Freund and Alain de Benoit, the leader of the so-called New Right in France. I consider, for my part, Schmitt's work to be a mere toolbox, but an effective one. As for its author, we can do without him. My reading of Schmitt was not only part of a personal political therapy. More importantly, it was also a step in the formation of my philosophical identity. From the beginning of my student years, I worked relentlessly, on Hegel's work, first on the science of logic and phenomenology of spirit, then on legal and political philosophy. So it was self-evident that towards the end of my student life, I began writing a PhD thesis devoted to this philosopher, focusing in particular on what I considered and still consider to be his innovative approach to the relationship between speculative and positive mode of thinking, or, if you like, between reason, which in Hegel is both dialectical and speculative, and understanding, of which the positive sciences such as physics or the law, are a fertile illustration. Out of personal interest, and no doubt also because the field of law had been largely neglected by Marxism, where the label superstructure was generally enough to discourage any attempt at refined analysis, I aimed to study this relationship in the domain of what Hegel calls the objective spirit, and first of all, in that of law, a concept to which Hegel gives an unusual extension by proceeding with what I have called his stratification, an operation that makes law much more than just the law of lawyers. In fact, the designation of all forms of social normativity. The incidental discovery of Carl Schmitt's work allowed me both to clarify and to give a new direction to these initial two extensive projects. On the one hand, Schmitt's approach to law seemed to me to be a particularly radical expression, because it was philosophically well informed, of the positivation or positivization. What is a better word?
Let's go with positivization right now.
Positivization. Schmitt's approach to law seemed to me to be a particular radical expression because it was philosophically well informed of the positivization and autonomization of law that had been underway since the 19th century, and of which legal positivism, of which Schmitt is moreover a constant opponent, was a sometimes naive doctrinal expression. On the other hand, however, Schmitt's thoughts seemed to me to have a particularly interesting relationship with that of Hegel, an author Schmitt knows very well, and whom he describes as a political mind in the highest sense, is a quote of Carl Schmitt. It then occurred to me the project to read Hegel's writings and those of Schmitt in mirror image, my conjecture being that the undoubtedly distorted and distorting image that Schmitt's decisionism gives of Hegel provides an interesting insight into his philosophy. Schmitt highlights certain unnoticed aspects, and helps to rectify a certain commonplace image of Hegel, let's say liberal reading, a mode of reading with which Schmitt's interpretation is in complete rupture. This is how my PhD project on Hegel and the positivization of law ultimately gave rise to a book entitled Hegel, Carl Schmitt, La politique, entre, spéculation et positivité, in which the latter, Carl Schmitt, plays the role of a revelator in the chemical sense of the term, of the complexity of Hegel's approach of law and politics, a complexity that the premises of Schmitt's decisionism do not justice to. If nothing else, my reading of Hegel through Schmitt's lens, if I can say so, has allowed me, at least I hope, to free myself from codified interpretive systems, conservative, liberal, Marxist, even fascist, that do not justice to the richness and complexity of a thought, that from Hegel, that never conforms to our stereotypical taxonomies. Hegel is always beside the point, which is what makes his thinking so exceptionally interesting, in my view. Carl Schmitt despite himself, bears witness to this in his own way, a testimony that must, of course, be received with caution. Why have I written a second book about Carl Schmitt? The first was not about Carl Schmitt, but about Hegel and Carl Schmitt. The second book is Que faire de Carl Schmitt. Nearly 20 years after the precedent, even though my previous confrontation between Schmitt and Hegel had, in my view at least, established the limits of a brilliant, terribly effective mode of thinking, but one afflicted with an insurmountable epistemological barrier, that of the decisionist logic of either or. Hegel refuses that logic because it forbids the task of bearing its finest fruits, in the sense that it closes the way to what Hegel calls speculative thinking. In a way, my intention in this second book was to settle the score after I had moved on to other questions. My current work in the philosophy of law, particularly on rights, draws more on contemporary Anglo-Saxon literature, as we will see tomorrow, if you want. Settling accounts after a long-standing relationship, as I did also some years ago with Hegel, by publishing the results of my immersion in his doctrine of the objective spirit, with the book translated with the title The Actual and the Rational, Hegel and Objective Spirit, and translated in English. And more recently with Kant's Practical Philosophy, with the book La Raison des Normes, from the year 2015, it was the text. It therefore seemed useful to me, first and foremost for myself, to sum up the results of my long engagement with Carl Schmitt's writings, which has never completely ceased since the publication of Hegel Carl Schmitt, even if it has become more sporadic, and to ask myself, as honestly as possible, what this work can and cannot contribute to a contemporary understanding of law and politics. This perspective explains the choice made in this book, for which I have been criticized by some colleagues, for example, Charles Larmor, of decontextualizing these writings as much as possible and examining only their conceptual content and theoretical relevance. It is true that it is not easy in many cases. This is, of course, the case for the writings from the Nazi period, during which Schmitt's articles and books were openly intended to support Hitler's fight against Weimar, Geneva, and Versailles, according to the subtitle given in 1940 to the collection of articles Positionen und Begriffe, positions and concepts, and to legitimize the National Socialist Weltanschauung. But in some writings, which are also marked by a militant zeal that is not in keeping with the ethos of a professor of constitutional law, things are more complicated. Take, for example, Der Hüter der Verfassung, the guardian of the Constitution, from year 1931, in which Schmitt argues for a plebiscitary shift in the Weimar regime, or, other example, Legalität und Legitimität, Legalité and legitimacy, from year 1932, a legal and political intervention written in the context of the final crisis of the Weimar Republic, in which Schmitt seeks, according to his opponents, to construct the legal basis for a constitutional coup d'etat and, according to himself, to save a regime in its death throes. Despite their obvious anti-democratic connotations, I believe that it is not useless to ask what, on a pure theoretical level, and by turning off the obvious highly political motivations, these texts, particularly the second one, legality and legitimacy, have to say about the need for legality to fit into a broader perspective of legitimacy that this, against Schmitt, does not necessarily unfold contra legem. The option to read Schmitt's writings out of context, as fair as possible, which is obviously not always feasible, also explains the reference made in the book to a whole range of authors whose work intersects in one way or another with Schmitt's, but who come from a very different perspective and sometimes vigorously opposed to him, such as Walter Benjamin, Blumenberg, Hans Blumenberg, Jürgen Habermas, Jacques Derrida, and Giorgio Agamben. The idea is not to track down some secret influence. Most of the authors I have just mentioned have more or less willingly recognized their debt to the author of the so-called theorem of secularization, as Hans Blumenberg puts it, but rather to establish on a case-by-case basis that a dialogue or confrontation with Schmitt or with certain Schmittian motives played a decisive role in the construction of their own theoretical identity. This approach also allows us to take a fresh look at issues that have recently regained relevance, such as the return of just war, of what I call post-state politics. In such issues, I hope that an analytical framework using Schmittian motives will be able to refine or modify the responses that are usually given to them. My conviction is that engaging with Schmitt's work, if maybe I forgot it. Maybe it's possible to. It is not. It is only to give an idea of the plan. Awesome. This approach also allows us to take a fresh look at issues that have recently regained relevance, such as the return of just war, of what I call post-state politics. In such issues, I hope that my conviction is that engaged with Schmitt's work, if accompanied with constant vigilance against any form of connivance, can be fruitful. It helps us formulate questions where common doxa tends to impose answers. Schmitt helps us, for example, to question the conditions of our democratic clean conscience and the presuppositions of the values in which we most deeply believe. Schmitt encourages us to re-examine legal norms in their concrete historicity and to draw conclusions from this historicity. For example, Schmitt concludes the following from the historical study of the concept of state in a paper entitled "The State as a Concrete Concept Linked to a Historical Era." I quote him, "It is misleading to use the word state indiscriminately in the context of the most diverse historical eras and to make it a universal concept." End of quote. At first glance, this observation seems rather banal. The state, too, has a history, and one cannot speak carelessly of the Greek, Roman, or Persian state as one speaks of the modern European state. But the ultimate consequence of this historicization of the concept of the state is brutally drawn in the preface to the 1963 reissue of the concept of the political. I quote, "The era of the state is at its end. Any further comment is now superfluous." This is an excellent example of how Carl Schmitt approached the history of ideas or concepts from the need to view the state historically and not as an universal concept valid for all peoples and all times. He concludes that the state form is obsolete and that it is now necessary to conceptualize politics in a different framework and with different tools than those developed by modern political philosophy. Many who accept the premise will refuse to agree with the conclusion, while recognizing that it is a valuable incentive to renew the way we approach the question of politics. In this regard, to refuse to consider what Carl Schmitt has to say, whether to engage with it or to refute it, simply because he was a Nazi, is just as lazy as to refuse to read Marx because of the catastrophes provoked by those claiming to follow Marx's doctrine. However, I also wanted to clearly mark the limits of the help that these writings can provide. In short, for me, it was a question of partir de Carl Schmitt in both senses of the French expression. It means taking him as a starting point and taking leave from him. I have often found it frightful to take Schmitt's writings as a starting point because they help to formulate impertinent, but in fact highly pertinent questions that, without Schmitt's help, cannot be asked with such incisiveness. One example among many is the conjunction between law and democracy, so obviously necessary that one, for example, Jürgen Habermas, is constantly told so today. Should we not rather consider that this relationship is made up of tensions and contradictions that always need to be resolved, which cannot be done solely through the resources of deliberative politics, as Habermas seems to believe. On issues such as the relationship between law and democracy, and more generally the relationship between law and politics, Schmitt forces us to stray from the well-marked path of our liberal certainties. And this is a useful exercise, I mean. But we must also partir de Carl Schmitt in another sense. We must split up with him when his way of formulating the issues under consideration becomes an obstacle. Just one example. I give many such examples in each chapter of the second part of the book. Once we have taken into account the arguments, and they are substantial, developed by legality and legitimacy against the illusion of the self-sufficiency of the legal order, it is possible, by taking a different way from that of Habermas, who develops massively anti-Schmitt arguments against Schmitt's plebiscitary conception of democracy, it's possible to raise the question of the legitimacy of legality anew. So we can reintroduce the idea of immanent norms and procedures that ultimately justify the formalism of the law and the rule of law disparaged by Schmitt, while refraining from invoking what Luhmann calls, aiming critically at Habermas, an idea of law above the law. But what remains clear, in my view, is that it is often from Schmitt on that we can depart from him, that we can fruitful overcome and preserve him. In contrary, the moral denial of his scandalous positions seems to me to be unfruitful. As example, let's consider the famous phrase, politics means the distinction between friend and enemy. First, this slogan from the concept of the political, the most famous work of Carl Schmitt, this slogan is rarely well understood since it is interpreted as a thesis on the essence of politics, whereas Schmitt explicitly rejects this interpretation and makes the friend-enemy distinction a mere topographical criterion. Where we encounter this kind of distinction, then we can be sure that we are dealing with something political. Second, I do not find it very fruitful to oppose to that conception the idea, which is certainly more decent, that politics had nothing to do with hostility, that politics is exclusively a matter of philia, that the only good politics is the politics of friendship. The expression is Derrida's, but is not my main target here, as Derrida himself entered into an uncompromising but charitable dialogue with Schmitt's position in the book Politique de l'amitié, certainly
Politics of friendship.
Politics of friendship. Yeah, all the work of Derrida is translated in English, of course. On certain subjects, particularly the 5 issues addressed in the second part of the book, theology, normativity, legitimacy, politics, and world, I have sought to show that Schmitt's analysis may lead us to modify our usual understanding of the issue, even if we have to rectify what needs to be rectified in them. How much time I have?
Oh, you have plenty of time. You can keep on going. Don't worry. Yeah. We still have the room for over an hour, so don't worry.
Oh, okay. A few words about the content and internal organization of the book, if you want. It consists of 2 parts. The first part, entitled An Essentially Controversial Thinker, begins with bibliographical considerations intended primarily for readers who are not acquainted with Schmitt's writings and the controversies they have sparked. It also examines the contrasting reception of his writings in different countries, including France, Italy, North America, and Germany, of course. particular attention is given to Schmitt's reception within the Frankfurt School, and more specifically by Habermas, whose own analyses, particularly in his early writings, have been influenced by Schmitt and James, despite his firm denials. I had a heavy conversation with the late Habermas about this question, but I am sure I have right, and not only I. The young Habermas was very profoundly influenced by Carl Schmitt. Okay, this is my opinion, not the opinion of Habermas himself. The second part of the book, which is purely theoretical, addresses 5 issues that I believe are central to Schmitt, attempting in each case to establish the lessons that can be drawn from his analysis and beyond them. Chapter 3, Theology, deals with the presumptive theological background of politics, highlighting the ambiguous nature of what Schmitt calls political theology. It shows, the chapter shows, attempts to show, that if Schmitt was able to define himself as a theologian of legal science, it was in a very particular sense, that of the jurist as a restrainer. This is St. Paul's phrase of the kat echon, which is used in many post-war texts of Schmitt, and to which, in my view, we should not, as some do today, attach undue importance. Ultimately, Schmitt is a theologian in the sense that he sees legal science as a bulwark against the entropic disintegration of world order, a classical conservative motif that should be subjected to criticism. The following chapter, chapter 4, entitled Normativity, analyzes the indirect debate between 2 opposing legal epistemologies, the normativist epistemology of Hans Kelsen and the decisionist epistemology professed by Schmitt during the 20s. From this confrontation, I draw certain non-Schmittian conclusions regarding the status of normative rationality. While it is important to note, with Schmitt, the irreducibility of the moment of decision, original or conclusive, it is not necessary to consider, as he does, that decision and rationality are antinomic. Moreover, as my former student Emmanuel Pasquier clearly shows with regard to international law, a close comparison of Kelsen's and Schmitt's texts reveals that they sometimes play opposite roles. Chapter 5 of the book, entitled Legitimacy, deals with the relationship between legality and legitimacy, as mentioned above. On this issue, while agreeing with Schmitt's premises, it is possible to define a different path from the one he follows in his 1932 work, Legality and Legitimacy, without adopting the reverse procedural formalism valued, not without reason, by Jürgen Habermas. It means we have to take into account the perpetual dialectic of the delegitimization and re-legitimization of legality, which makes it possible to take seriously the pathologies of democracy highlighted by Schmitt without drawing the anti-democratic conclusions that he himself drew even before 1933. Chapter 6 of the book, Politics, considers Schmitt's most famous essay, the essay on the concept of the political, and proposes to go beyond the simplifications to which it has given rise and which Schmitt encouraged incidentally. To say that the political is illustrated by the relationship of hostility does not mean that this relationship is, for Schmitt, the essence or substance of the political. He even explicitly states the opposite. Going beyond Schmitt's characterization of politics, I underline in this chapter the importance of taking into account what I call the political layer of law, a layer that the various kinds of normativism try in vain to erase. Finally, chapter 7, World, reconstructs Carl Schmitt's argument against the project falsely attributed to Kant of a political unification of the world. These arguments are based on a cryptic theology of history centered on Paul's idea, mentioned above, of the katechon. I show that it is very difficult to translate the word katechon in the letter to the Corinthians. Katechon means something what retains.
Yeah, holds back or restrains. Yeah.
So, Paul speaks 2 times. One time of o katechon, and the other time on to katechon. I say who retains and what retains. It is completely enigmatic, this use of the word katechon in St. Paul's letter. But Schmitt uses the term as equivalent to what or which restrain the end of the times, the apocalypse.
Holds back the apocalypse. Yeah.
And he said that is the Roman Empire, or now another empire, who restrain the entropy of the world. So, I show that it is not necessary to Schmitt's reasoning, as this reference to the katechon, from which we can nevertheless learn an important lesson. It is true that the law, in its primary sense of nomos, had something to do with the act of taking, nehmen in German, with the idea of an original seizure or predation that the law strives to legitimize. Schmitt speaks of Landnahme, Landseizur, as a paradigm of the original concept of nomos. Law is primarily taking something. Of course, it is very questionable, but interessant, very interesting as a thesis. The model is, of course, the conquest of the New World, the taking of the New World by the Europeans, different European states. But my thesis is that the world as a whole is inappropriable, which is why it remains beyond grasp. The world, the unity of the world, is not a legal object. On the various points that have just been raised, I'm convinced that Schmitt's thought-provoking approach modifies or inflects in a fruitful way the terms in which the right questions are asked. It is clear that the answers Schmitt provides may not suit us because they may clash with some of our most deeply held convictions. But his questions prompt us to refine and clarify our own answers, just as Schmitt's ideas sometimes force use to reformulate our questions or some of them. My reading of Schmitt takes seriously his constant claim to be first and foremost a jurist. I'm a jurist, not a theologian, he writes in his Ex Captivitate Salus, a kind of meditation written during his imprisonment in Nuremberg, after the Second World War, of course. In other words, I do not read Schmitt as a misleaded political philosopher, as Leo Strauss and Kojève did, nor as a political theologian, as Heinrich Meyer, a Straussian commentator, did. Even so, Schmitt invented the term political theology and published 2 books with that title. In my view, it is always as a jurist, but a political jurist, not a normativist one, that Schmitt addresses political matters, whether in his decisionist period, the writings of the 20s, or after his conversion to institutionalism, or finally, when he works as a very political historian of international law in the important book, The Nomos of the Earth, and other writings from the 1950s and 60s. In other words, I believe that it is because Schmitt is first and foremost a jurist, not only in terms of the matters he studies, but also in his way of thinking, which is very casuistic, if you will, that he is of interest for philosophers. I'm not jurist, I am philosopher. Provided, of course, that what we mean by philosophy accords some importance to law and legal reasoning. For my part, the writings of Schmitt that I find most interesting philosophically are his most technically legal writings, such as the Theory of the Constitution, or Legality and Legitimacy, and the papers collected in his writings on constitutional law, verfassungsrechtliche Aufsätze, as well as his analysis of the history of legal doctrines, since as the book on dictatorship or the Nomos of the Earth. And not necessarily his more essayistic texts, such as the concept of the political, the true political theologies, and other lesser-known essays, such as the short work Hamlet and Hecuba, or The Tyranny of Values. Of course, this is not to deny the interest of Schmitt's essays, like the aforementioned writings, his book on political romanticism, or his texts on Catholicism. He was Catholic, but after his divorce in the year 1923, he was excommunicated, but remains Catholic. Catholic in the sense of the Council of Trent, of course, tradition. The Church, the Catholic Church, is a conservative force that the world only that the world don't remain what a world. Okay. But it will be a mistake, in my opinion, to base an overall interpretation of Carl Schmitt thought on these writings, which remain exoteric, even if they are more attractive than strictly legal works. I remain convinced that the hardcore of Schmitt's thought lies in his writings as a jurist. No, 10 minutes?
Yeah, sure.
Okay, thank you. When discussing Carl Schmitt, one cannot fail to mention his adherence to National Socialism. As will be clear from the above, and as I explain in detail in the book, I have chosen not to focus on Schmitt's Nazism. I give some explanation about this choice. There is a good and simple reason for this. Factually speaking, there is no debate on this subject. From April 1933 until the German defeat, Carl Schmitt was a National Socialist with no qualms. He even emphasizes this, going in some of his writings far beyond what most of his academic colleagues dared to do. We must know that the vast majority of the jurists were without problem adhered without problem to the National Socialism, as Carl Schmitt himself. But he had extremely underlined this adhesion. Too much. A minimum of information, and today we have a maximum of information, is enough to convince us that the answer to the question, was Carl Schmitt a Nazi, is beyond doubt. In this regard, I reject the strategies of the apologists like Günther Maschke and Helmut Quaritch and others. We have sought to explain Carl Schmitt's support for Nazism, that is, in fact, to make it acceptable. But, and this is a second reason, once the facts have been established, and they must be, the discussion is not very interesting. I also feel that those who, sometimes with talent, strive to show that there is a Nazi substance to Schmitt's thinking, have a strange idea of what thinking is. Furthermore, on a strictly empirical level, everything seems to indicate that Schmitt, relying in the spring of 1933 to a party that he had advocated banning a few months earlier, 3-4 months earlier, at the end of the text, legality and legitimacy, he proposed the interdiction of the Communist Party and of the National Socialist Party. Communist Party and National Socialist Party received to that time about 50% of the votes. But he advocates for the interdiction of those parties because they not adhere to the substance of the Constitution. And this is interesting because after the war, in Germany, was introduced in the Constitution of the Federal Republic a stipulation about the fidelity to Constitution. And for example, the Communist Party in the 50s, during the 50s, were banned because the communist, the program of the Communist Party of West Germany are not in accordance with the values included in the German Constitution. It is interesting, and Schmittian idea was introduced in the Constitution of West Germany after the World War. Okay. In 1932, end of 1932, Schmitt preconized the interdiction of the Nazi Party. 3 months later, he becomes adherent of the National Socialist Party. Of course, it is opportunism. Opportunism and careerism is clear, and with a certain success. Goering had him appointed state councillor, Staatsrat, and Schmitt briefly held the presidency of the German Law Academy, created by the new regime to counter existing corporate institutions, such as the Association of Constitutional Lawyers, before being removed due to internal conflicts within the National Socialist Party and the rise of some fanatic SS lawyers. But these were lying. Whatever the ulterior motives, was revolting in its excess, particularly on 2 occasions. When first occasion, Schmitt published a provocative article in 1934 entitled Der Führer schützt das Recht, the Führer protects the law, in order to justify the night of the long knives, that is the elimination of Rome and the SA. That is, if you know the film of Visconti, The Damned, this is the end of the film, this elimination of the SA from the SS in 1943. And Schmitt had the idea to justify this operation juridically by the idea that der Führer schützt das Recht. The Führer is the defensor of the law. So everything he makes is is the law. An aberration. The other German jurists, Nazi jurists, were more cautious. But I explain that as a tentative to faire oublier.
Oh yes, to make you forget.
Yeah, his former positions. Okay. And second, more horrible. In 1933, Schmitt organized the horrible Judentagung, bringing together the elite of German law professors to denounce, I quote, the misdeeds of the Jewish spirit in German legal science. This is something incredible. The content of Schmitt's own conference and speech, and of the others. But okay. These facts and others are well known. No. They are undoubtedly a hyperbolic manifestation of what someone called the zeal of the convert. But that does not make them excusable, and in a sense, the dismissal of Schmitt's case in Nuremberg was not justified, even if no criminal act could be attributed to him. He killed nobody himself. Okay. It is true that many other leading academics were in the same situation, and unlike Schmitt, were not even forced into retirement. This gave Schmitt the feeling that he had paid very little indeed, retreat. He had paid for the others and led to a complacent self-pity that is evident in the glossarium, the journal he wrote in 1947 and following years, during and after his detention, which, like Heidegger's Black Notebooks, is full of anti-Semitic remarks after the war. Why, nevertheless, did I take an interest in Carl Schmitt, knowing well what he stood for? For the following reason. When you read his writings, it is clear, in my opinion, that with a few exceptions, they resist the reductio ad Hitlerum that Leo Strauss spoke of ironically in the case of Heidegger, and which he always refrained from practicing himself, whether in the case of Heidegger or Schmitt, whose concept of political Strauss commented on with brilliant insight. If Carl Schmitt had written only the texts just mentioned, if his overall scientific output had been comparable to that of Nazi scribblers, such as Reinhard Höhn or Otto Kohlreuter, whose work was scientifically indigent, he would have been forgotten long ago, as the others have been. But this is not the case. And therein lies the problem. Here, the similarity with Heidegger's case is striking. This comparison is not coincidental. In both cases, an author at the forefront of his discipline openly relied to a regime that viewed intellectuals with great suspicion. The Nazis had a hate against intellectuals. This is why intellectuals like Heidegger and Schmitt have the desire to be recognized by a party and by whose have a hate against intellectuals. The question is open. We know that this common, Schmitt and Heidegger, their common allegiance gave rise to a correspondence between the two men, at least during the early years of Hitler's regime. But precise documentation is lacking pending the complete opening of the archives. Beyond the biographical peculiarities, such cases raise the problem of the relationship between theory, morality, and politics. How could an author, philosopher, or jurist of such exceptional stature have the hope of becoming the intellectual leader of a regime that hated South? In Heidegger's case, the publication of the Black Notebooks shows that his adherence to National Socialism and the most abject aspects of its ideology was not merely opportunistic. In Schmitt's case, opportunism and careerism undoubtedly played a significant role, but this does not explain everything. This leads to a profound question that only a few have addressed, such as Jakob Taubes in his short book, Ad Carl Schmitt, how it is possible that powerful and inventive minds, such as Heidegger and Schmitt, could identify and with such abandon with National Socialism. I have no philosophical answer to such a question, which is by no means secondary. Like everyone else, I only have elements of basic psychology at my disposal, so aspiration to power, etc. This is one of the reasons why I did not feel compelled to make the question of Nazism, without evading it, the focus of a philosophical and critical reading of Schmitt, given that the choices made by the individual are definitively reprehensible, but not totally inexplicable. My position is therefore distinct from that of Schmitt's apologists and his detractors. On the one hand, I don't believe that Schmitt's relying to National Socialism is a detail. On the other hand, I maintain that it is legitimate and fruitful to examine his writings when they say something original and powerful, which seems obvious to me in a number of cases. In some cases, we can and indeed must discuss Carl Schmitt's writing. This is what his most distinguished opponent have done. Okay, thank you.